In this short video, we're going to look at an evaluation essay on theft. Evaluation essays appear on exam 3, and you'll have to answer one on criminal, one on contract, one on tort. This question is, those who argue that the actus reus of theft is too complicated are quite wrong. The rules are simple, clear, and raise no great problems. Discuss the extent to which this statement is accurate. As usual, it's worth 25 marks and you would have 45 minutes to answer. I've included this image here to remind you of the fact that this statement is wrong. The actus reus of theft is extremely complicated and we need to show that in an essay. Now, whilst the essay question asks you just for the actus reus of theft, you will have to mention the mens rea of theft to help explain that the complicated law on theft isn't helped by also having a complicated mens rea. If we scroll down to my suggested answer then, as usual, my AO1 is black, my AO2 is red, and I've highlighted cases and the sections of the Theft Act. You can see my introduction links to the question because it says straight away that the Theft Act was designed to codify the old offence of larceny. The idea was to make the law simpler, but actually it's made the law much more complex, and that's a nice opener into it. So again, some AO2 here. Section 1.1 gives a definition for theft which looks simple, but the case law shows otherwise. And that leads me in quite nicely to my essay. I've got my full definition there. Theft is the appropriation of property belonging to another, with the mens rea being dishonest intention to permanently deprive. I'm going to explain each element of theft and evaluate as I go. Now, to make it easier for you to follow, I've put subheadings in my essay. You can see if I scroll down, subheadings that show the different elements of theft that I'm going to talk about. First element of the actus reus is appropriation. So I've explained what that means, citing my cases. And I've made the point there that appropriation is much wider than what you would expect. You would expect it means taking, but we've seen through the cases that it's much wider than that. It's likely to surprise the public. Some of these cases, switching labels, tugging a handbag, etc. Whilst it's wider than we would expect, of course, these cases are useful because it means it will apply to everyday situations, which we need it to do. It's been argued that the word appropriation is defined too widely. I'm just highlighting that in red. That's an AO2 point there, sorry about that. And then I'm looking at some cases which have defined this word particularly widely. In Lawrence, it was held that consent, even if you've got consent, you can have an appropriation. And wider still, in Hinks, it was held that you can have an appropriation even where property is given as a gift. Quite a controversial case, that one. So my evaluation of those cases here is to say that the critics say that these cases have extended the meaning of appropriation past the intentions of Parliament. In other words, it isn't what Parliament intended the law to be when they passed the Act. And of course, judges are unelected, so it's undemocratic for them to be doing that. And of course, that's going to place a lot of emphasis on dishonest mens rea, because if basically anything can be appropriation, in order for it to be a theft, we're going to have to rely on the fact that the person was dishonest. But I suppose the good aspects of Lawrence and Hinks, the reason we made those decisions, is that in both cases we were protecting very vulnerable victims. In Lawrence, it was someone who didn't speak the language that was being taken advantage of. And in Hinks, it was a person with a very low IQ, who again seemed to be being taken advantage of. So there was a reason to justify those decisions. Still on appropriation, section 3.1 says that you can appropriate where there's a later assumption of a right. So that's where the defendant starts off borrowing something, fully intending to give it back. but then they later decide, oh, actually, I'm going to keep it. And then it becomes theft. So I suppose it's complicated to have this section in there, but of course we need it because it's going to be quite common in life that situation's going to happen, that an honest borrowing later becomes a dishonest theft. So I've dealt with appropriation. I'm now looking at the next element of the actus reus, which is property. It's defined in section 4. And I've pointed out that Kelly and Lindsay, Oxford and Moss seem like strange cases. And I've also said that it's a bit odd, really, that section 4 lists what isn't property rather than listing what is property. And again, that's just showing that the law is quite complicated if we're bothering to list things that aren't included. Better to list things that are, really. Belonging to another, then, is my next element of the actus reus. Just like appropriation, belonging to another is given a very wide definition by the Theft Act. It includes possession, control, as well as proprietary interest. That might surprise the public. I think most people would expect that belonging to another means that they own it. But of course, in Turner, we saw that belonging to another can be just if you're in possession or control of it at that particular time. So in Turner, he was guilty of stealing his own car from a garage because the garage were in control of it at that time. That seems very strange. Again, probably the general public aren't aware that that's the case. But of course, that broad meaning of belonging to another makes the job easier for the prosecution because in every theft case, they don't have to scrat around trying to prove who the legal owner is. They just have to look at who has control or possession at the time. And of course, in Turner, you can see that rule also protects businesses from customers taking property back before they've paid for it. Still on belonging to another, we've got woodman. So you can be guilty of stealing property even if the person doesn't know that they have it. Again, that can seem a little bit odd at first, but really that's a very fair decision because a crime's still a crime even if the victim is unaware that it's occurred. We've also got the issue, we've mentioned it already in Hinks. Hinks links to appropriation. It also links to belonging to another. Because as I've put there, some people question how defendants can appropriate property belonging to another if it's been validly transferred to them, if it's been given to them as a gift. If something's a gift, clearly it belongs to you and not another person. So Hinks was a bit of a controversial case, as I've put there. And the law lords in that case were not in agreement. They were divided on whether a gift could or should be appropriation or not. And if the law lords are in disagreement, that really illustrates that the law is very complicated if they don't even agree on it. You've then got on belonging to another section 5, subsection 3, property received under an obligation. You've also got property received by mistake, section 5, subsection 4. I've not put much detail about that at all. If you had time in the exam, you could add in some more cases here. You could put Davidge and Burnett, Kleinberg and Marsden. You could drop them in for property under an obligation. I've kept it quite short, really, because when you look at the length of my essay, there's quite a lot to write here. And probably what I've written is sort of realistic in the amount of time, in 45 minutes you'd have. But I could have put more there. So those sections are complicated, but they are necessary to cover everyday situations. Being overpaid by an employer, by a shop, being given too much change, that's going to be a day-to-day occurrence. So it's important that we can cover that. Equally, if you promise to do something with a piece of property and then you do something else with it, it's fair enough that that should be theft. So although these sections are complicated, They are necessary to cover everyday situations. I've put Attorney General's reference there for being overpaid. I have sort of put the counter argument that actually, whilst we want being overpaid and keeping the money to be theft, there is, of course, a practical problem in proving that the defendant noticed that they've been overpaid or given too much change. Most of the time, not most of the time, that's probably not fair. A lot of the time, I would imagine, if someone's given too much change in a shop, they're going to pretend they've not noticed. Really difficult to prove that they did notice, unless it's a huge overpayment, of course. So there are practical problems in proving that these sections have been met. So there we are. We've so far explained a complicated actus reus there, and the question asks you just for the actus reus. But as I said before, I'm going to say a little bit, and you can see it's quite small compared to my actus reus. I'm going to say a little bit about the mens rea, because if I'm saying the actus reus is complicated, I want to sort of emphasise that that's made even worse by also having a complicated mens rea. So first element of mens rea is dishonesty. There's no positive definition of what dishonesty is. Section 2 lists 3 situations which are not dishonest. Again, you could have maybe put them in brackets there, but I'm conscious of time. So it's a bit weird to list situations which are not dishonest, rather than just giving a clear definition of what is dishonest. We did have the case of Gosh, which gave a 2-part test for dishonesty. But of course, the recent case of Ivy and Genting disapproved the second limb. So there's a bit of uncertainty here about where the law's going with dishonesty. I've also put another problem here, is that the objective concept of dishonesty relies on the notions of honest and ordinary people. Some say that's a circular argument. Geary is an academic who said that what is dishonest will depend on the social context, on the culture. What is deemed dishonest in one situation may not be in another. So, real problems here with dishonesty. Intention to deprive is also problematic. Section 6.1 talks about borrowing or lending being equivalent to an outright taking or disposal. That's ambiguous, difficult to apply. The court struggled to apply that test in the case of Lloyd. Again, a lot of it is going to come down to the individual circumstances of the case. So you can see here that the law, with all these elements, appropriation, property, belonging to another, dishonesty, intention to permanently deprive, each element is complicated, which clearly means that this question at the beginning with this statement, the statement says it's simple, clear, no great problems. Of course, that's not true. We've established through going through the different elements that it isn't clear and it is very complicated. Nice conclusion would be to talk about reforms. Glazebrook wants to codify in the Act everything the defendant cannot be dishonest for. But there is a concern that if we add more provisions to the Act, we're actually just going to make it worse. But whatever we decide to do, my sort of conclusion there should probably be read as well. Sorry about that. What is clear is the actus reus of theft is extremely complicated. Reform is needed to rectify these problems. As usual, that's your mark scheme that you're following at the end there. 10 marks for your AO1, 15 for your AO2. And you can see that I've got a nice balance there of black and red of AO1 and AO2. Nice logical structure going through each element of theft in turn, pointing out the problems. And that's what you need to do on an evaluation of theft.